Any mention?
Yes.
From the daily list, item number 1.
Yes, Your Lordship.
Lordship.
Yes.
Lordship, this is an appeal preferred against the order passed by Learned Income Tax Appellate Tribunal, Lordship, dated 12 December 2022, Lordship.
263.
Lordship.
What is the question of law?
Lordship, the department has framed 4 questions of substantial questions of law, Lordship.
Yeah.
Lordship, may I allow you to myself commit this, Lordship.
So we will admit the matter.
Yep, Your Lordship, I could not hear.
We are admitting the matter. It's coming up for admission.
Oh, Lordship, there is no question of finding of facts only recorded and covered by the Supreme Court judgment directly on this issue.
Yes, yes. You file your objections, we'll pass orders.
I could not get you.
You file your objections, we'll pass orders. Because I also went through the papers. There appears to be no question of law, but now they have raised one point. So far as the question number 3 is concerned, that alone appears to be the question of law. Any other thing may not arise.
But that question of law is also covered, Your Honor, already on this issue, Your Lordship. That question of law, if you only see question number 3.
Yes. Yes, sir.
Whether the Honorable has any law allowing the appeal of the system which is following hybrid system of accounting with respect to this is the question, Your Lordship is asking.
In contravention of section 445 of the IT Act 1961.
No, that issue is covered because the finding of fact recorded that this income has not accrued, and this issue has been dealt by the Punjab and Haryana High Court, which has been referred by the tribunal, and which has been affirmed by the Supreme Court, and SLP has been dismissed. And similar issue has come up in Excel Industry in the Supreme Court. I may ask Mr. Jindal is there to hand over the item number, case law number 1, Dakshin Haryana case, which is exactly on the same issue. Case number 1. Case number 1. Your Lordship, you could get this order?
Yes, yes.
If Your Honor will see
2018 TMI.
this is exactly the same question, whether on the facts and circumstances of the case, the learned ITD was right in dismissing revenue appeal, upholding the order of the commissioner, whereby he had deleted the addition of 195 crore made by the AO on account of non-inclusion of surcharge levied on electricity bill, yet not relied during the year in his total income. Though the respondent has regularly been following the mercantile system of accounting. And then they have dealt this issue. And in my case, and this judgment has been affirmed by the Supreme Court. If you're not, my friend can give the Supreme order of the Supreme Court where the SLP has been dismissed. Item number 4. If you, Mr. Jindal, if you can head over the item number 4, Supreme Court judgment, 1 page that that's issue.
Lordship, it's part of this compilation itself, my lord. The compilation that Lordship is holding,
Compilation.
this small compilation, it is part of that only, my lord. 2019 8 TMI.
2018 10 TMI.
No, my lord. 2019 8 TMI 193.
The 1 page order Supreme Court on again that approval of income.
Or 2008 TMI.
Yes. We do not see any reason to interfere with the order of the High Court of Special exact electricity board electricity issue which is dealt with, Your Honor. And this has been relied upon by the ITD.
Lordship,
There's no question, a substantial question of law. It's a question of fact.
Lordship, I humbly pray that the matter may be admitted. I am led by Mr. Kyle, Lordship, who is a senior standing counsel for the department, who is from Guwahati, Lordship, who couldn't be here today. I'm sure on the next date, he'll be able to satisfy my lords on this point of objection, Lordship.
It should not be, Lordship. Then you have to argue if your Lordship see another judgment of the Supreme Court, Excel Industry, which is the last your judgment. If Your Honor may turn to the Excel Industries.
Mr. Khan, you're Mr. Khan or you're Mr. Jain?
Yes, Mr. Jain, I'm Jain, sir.
Mr. Jain, see, your friend said that the senior counsel is not available.
So let him go, senior counsel come, then we can argue without admission, Your Honor. Then
Yes.
we can discuss about admission.
Really, what's the matter? Shall we have it on Friday?
Lordship.
Friday.
Monday, Lordship, if your Lordships can have it on Monday, Lordship.
Friday, I require work. My brother is on official work. I can't be without work. At least one case we can dispose of.
Lordship.
Item number 2.
Friday,
Hello, my Lordship.
this Friday.
Oblige your Lordship.
Because in this, paper book could be completed only yesterday and we submitted. So
It may come up another day. We'll give him a copy. My friend also hasn't received it.
He's not having a copy.
No, my lord.
We gave it in the office, but my friend hasn't got it. So maybe a short time.
It's a batch or only one case?
One.
Madam? Only one case.
Two appellants or three? Three appellants. There are three appellants.
Man.
Three appellants are before the.
Man. Same. If your lordship can accommodate after 15th March, madam. After 15th March.
Yes. 18th March.
My lord.
On the request of the appellant, paper book has already been filed. On the request of the appellant, post the matter on 18th March.
Item number 4.
If you, all of you are address the argument, we will finish 23 matters.
But
I've just filed my paper books yesterday, madam, in this matter. I'm praying for a week's time or 2 weeks. Finally, argue this matter. I'm led by Sir Khan.
Yes, is there Mr. Khan? Is there? Yes.
Lordship.
At the request of the appellant, post on
I'll collect this.
4th of March. Today we are on 27th. 5th of March.
My lord.
5th of March.
Item number 5.
Paper book has already been filed.
Connected. This is connected, my lord. The next item as well.
There are 3 cases, no?
2 of them, my 2.
Item number 6.
34 and 35. Good. Yes.
May it please your lordships. Lordship, this is a criminal appeal under section 378 against conviction under section 302 of IPC.
Delay.
My lord, the delay had been condoned by the order dated 12/2/2024. In the miss case.
Oh, yes.
In the miss case. After that, the appeal has been registered. I pray that the LCR may be called for and the appeal may be admitted, my lord. The LCR, the lower court records may be called for and the appeal
Let
may
me
be.
call for a record. In the meantime, paper book also required to be
Paper
filed.
book, my lord, since I'm a legal
Half
aid
of the
counsel, it
records.
will be by the registry.
Yes. Also records a paper book to be filed.
Lordship, in this case, the registry will have to prepare the paper book.
The legal aid,
Yes, Lordship.
paper book to be called for, registry is directed to prepare the paper book. One month. 1 month.
My lord.
Oh,
Deeply obliged, my lord.
Item number 7.
Amid basis, your lordship. Lordship, I have filed one miss case, your lordship, for imputing 3 partners, your lordship, in the straight appeal.
Yes. What is this miscellaneous petition?
This is for implementing, your lordship, 3 parties, that is the signatories to the agreement deed, your lordship. Because your lordship, in the writ petition, this party have not been implemented, your lordship.
This is a case where initially the quantum was fixed, it was not acceptable, 6 crores or so.
Lordship, yes.
This is the case.
Lordship, because what happened, Your Lordship, this is the case. This is a water project, Your Lordship. It was completed in the year 2015, Your Lordship. What happened, Your Lordship, because of the rising of water level, Your Lordship, in 2011, Your Lordship, there was some land had been submerged, Your Lordship. So in 2016, Your Lordship, they filed a writ
So
petition.
according to you, it's an act of God.
Lordship, yes. And another aspect of the matter also, Your Lordship, the dam, the project on which it have been constructed also, Your Lordship, that land was donated by the writ appellant only, Your Lordship. Our contention, Your Lordship, is that having donated the land, Your Lordship, the writ appellant are not entitled to claim any compensation, Your Lordship.
Clear any compensation.
Lordship, yes.
Claim any compensation.
Lordship, yes. Land compensation, Your Lordship. So, Your Lordship, that's why I filed this miscellaneous application, Your Lordship, to implead, because this land had been donated, Your Lordship.
To implead.
Lordship, yes.
To implead whom?
3 parties, Your Lordship, that is the signatories to the agreement, Your Lordship. If Lordship is pleased to kindly come to page 13 to the misapplication, Annexure A. Lordship will find the signature of those parties which we would like to implead them, Lordship, at page 14. Next page, Your Lordship. These are the village authority, Your Lordship. And Your Lordship, below Your Lordship, will kindly see the appellant, Your Lordship, was the signatory to that agreement, Your Lordship. And Lordship, at page 15, Your Lordship, will find, Lordship, the land.
Notice. Do you have any objection?
My lord, I have an objection, my lord. I have filed my affidavit to resist the application. My lord, may I take my... My lord, I filed two show cause reply. First, filed by the appellant number 1. My lord. May I take lordship attention first to page number 21 of my application. 21 of my show cause.
21.
My lord, in the year 2011, inundation started. Therefore, the department asked us to come for site inspection. This is 2011. Thereafter, my lord, the survey was conducted, page number 22, survey conducted by the survey department, and the name of the writ petitioners are mentioned there. Serial number 2 onwards. 10 landowners are there, my lord. Out of them, 9 owners are before my lordship. 1 did not come for filing writ petition. Now, all the names of the 10 owners are mentioned as a landowner, along with the
Owners? 10 owners name.
landowners. 10 landowners are there. Out of 10 landowners, 9 has filed writ petition. But, and their names are mentioned in the survey paper. Thereafter, what happened, my lord, page number 24, Lordship kindly come. Government has in 2014 prepared a draft section 4 notification. There also the name of the writ petitioner started from plot number 2, page number 24, along with their areas has been reflected as a landowner. Thereafter, my lord, what happened? Page number 29. The collector has reminded the government that if you are proceeding to acquire the land, the new Act 2013 Act would be applicable. The last paragraph made written below. Please note that engage the office would intend to proceed with the land acquisition, sections and such, as mentioned in the earlier letter, will no longer be relevant. Instead, action to be initiated as per the new Act 2013. It was reminded. My lord, nothing was happened. Therefore, we filed the first writ petition before this single bench. Government has filed a detailed affidavit. And detailed affidavit, my lord, page number 30. page number 30. And may I come to relevant portion, para 7 of that affidavit. May I come straight to page number 40, my lord, a very lengthy paragraph. Here the government has conducted survey along with the presence of the landowners, and the page number 40, may I read, my lord. Consequent upon the detailed survey and assessment of the submerged area of the land, Office of the Deputy Commissioner East Khasi Hills, Shillong, estimated the probable cost of the land amounting to rupees such and such only as per the date indicated herein below. My lord, the landowners, serial number 2 is a repetition number 1. So, Maman, her area is mentioned, estimated cost also mentioned. Government has admitted that we are the landowner. They never said that my land has been donated to a headman. They never say. Now, may I come the next page number 42. My lord. Following the survey, assessment estimation by the competent authority for the areas of land affected, proposal for payment of compensation was formulated by the PHG and sent to the government for consideration. The proposal investigates payment of compensation to the affected landowners whose cultivation process is affected due to the submergence of the land. For period during this year, the year to the affected landowners as per assessment made by competent authority. They have the proposal for payment of compensation to the landowners of the submerged areas of the land due to construction of RCC wide of the water supply scheme has been sent to the government, but the same is still pending with the government for considerations. My lord, they say that they were not taking your land. The land is not under submersions. That was the issue. Let a single bench, my lord, pass an order. My lord, page number 47. First order passed by the single bench.
The issue was whether the government was interested in taking their lands or not.
Or not. And by land is,
Actually, they have taken a stand that the lands are going to be acquired.
Yes.
And compensation is nominal amount has been fixed.
yes,
So at a later point of time, they have taken a stand that the lands are not going to be acquired
yes,
after the lands have got submerged in the water.
yes, yes, my lord. And
So
this,
according to you, the deemed acquisition and you are entitled to compensation.
my lord, according to me, my land is under the water. Government said no, not under the water, and we are not acquiring your land. That was a dispute.
You know?
Government take a stand that the land is not under water. Therefore, we came for survey, and the proposal has been made, but government final approval is awaiting. So we are not taking your land as of now. Therefore, the learned single bench passed an order. Page number 49.
So how do you compel them to take their lands?
My lord, I'll come to that. Your lordship, give me some minutes, my lord. I'll come to that, my lord. How the situation is trying to change now. Page number 49.
49.
49. Order was passed on 8/9/2016.
The para?
My lord, page number 49
Yes.
is the High Court order, it's the single bench order. May I come to relevant para, para 3, page number 51. My lord, the Sunset General Council for the petitioner submits that due to heavy rainfall in such a village, the land of petitioner have eroded. So necessary direction will be given to the respondents to provide compensation. That was wrong finding. It's not erosion, it's submersion. But such. After hearing both the bar councils, I am of the considered view that the matter is too premature to give any direction. Let the petitioner make a representation before the concerned deputy commissioner, stating all of the facts, and the commissioner of the concerned district is hereby directed to look into grievance or to settle the matter within 1 month from the date of receipt of the representations. We found agree because it is not the case of erosion, so we filed a writ appeal, and the writ appeal, my lord, division bench passed an order, page number, my lord, 53. Order was passed on 26/9/2017. And I come to, my lord, the next page, my lord, page number 54, in the middle of the second paragraph, my lord, to save lordship time. Taking note of the submissions made and the pleadings of the parties, we find no case for interference at this juncture, my lord, it's important, at this juncture, and we are inclined to endorse the views of the learned single judge that the appellant petitioner ought to make appropriate representation. Such a course appears more of a necessary in view of the several disputed questions of facts being involved in the matter, However, in the totality of circumstances, we are of the view that instead of requiring the Deputy Commissioner to take a call on the representation of the appellants, petitioners, appropriate would be that such a representation be made to the Chief Secretary to the Government of Meghalaya, who may take appropriate decision thereupon expeditiously. Accordingly, and in view of the above, while we decline to interfere, and this intercourt will be dismissed, but subject to the modification of the order impugns, that the petitioner appellants may make appropriate representation of Chief Secretary to the Government of Meghalaya within 4 weeks from today. Upon the petitioner appellants making such a presentation, it would be expected of the Chief Secretary to take appropriate decisions thereupon, expeditiously preferable within 90 days of absence. Now, we filed page number 56, we filed the detailed representations, page number 56, on 6 October itself. We claim compensation under the new act. And thereafter, my lord, the Chief Secretary has taken a decision. My lord, we come to page number 63.
60?
63, page number 63.
Oh.
My lord, is a disposal of my representation. Now, the noting of the Principal Secretary on the top matter was discussed yesterday. A clear note on the status of the Water Combined Water Supply Scheme placed below for perusal and information of the Chief Secretary by order of the High Court of Meghalaya, which may be seen at flag B below for its decision. Now, Chief Secretary his decision is this, my lord. Since this is a High Court case where Chief Secretary is a party, we give assurance that the amount for land acquisition be placed with the department by planning, finance, lest we face contempt proceeding for delay. As proposed, in the meantime, file put up draft reply to the petitioner indicating that position is urgent. So Chief Secretary has taken decisions that we will take the land. Appropriate compensation will be paid. Page number 65. Accordingly, we were informed. Appellants were informed. Page number 65. Informed on 14 March. May I read to the content. 65. In reference to the above and in accordance with the order of the High Court of Meghalaya.
So what is the compensation you are willing to pay, sir? What is the compensation you are willing? See, the problem arises that initially you decided to acquire, correct? And thereafter you decided not to acquire. Subject, first you listen to us, then you answer. Initially you wanted to acquire. Then, if they have been submerged in the water, you decided not to do that. At that time you offered about 6 point some crores to these employees. From the record it appears. We listen to you. Then, what happened? It was prior to 2012. So 2013 Act has come into force. So they want away the better benefits under the 2013 Act. It appears like that.
Yes.
Lordship, that six crews something, your lordship, that is only a payment for damage because of the occurrence of 2011, your lordship. The land was never acquired, your lordship. And the government had taken a decision, your lordship, a decision that we are not going to acquire the land, your lordship, in view of the fact that the land had been donated by the red appellant, your lordship. If lordship can we come to the affidavit filed by the government. Lordship will kindly come to...
What is your stand?
Our stand, your lordship, is that the land had been donated. The question of payment of compensation does not arise. Lordship kindly appreciate your lordship.
Where is the donation, sir?
Lordship will find it. Lordship will find it in the miss case. That is the deed agreement, your lordship, at page 13 of the miss case. And lordship, in the writ appeal.
So according to you, people have donated the land to you and question of payment of compensation doesn't arise.
Doesn't arise, your lordship. Then lordship will kindly...
Where is the proof that they donated you?
Lordship kindly come to the misapplication, your lordship, at page 13. Misapplication at page 13, your lordship. Lordship, at page 13 of the misapplication. May I read it, your lordship?
So these are the person who want them to be implemented here.
Lordship, yes. Then Lordship, kindly consider, Your Lordship, this is a project of 10 crores, Your Lordship. 10 crores, Your Lordship. If we are to acquire the land and pay compensation, the compensation will come to around 100 crores, Your Lordship, plus compensation, interest, Your Lordship. So that is why, Your Lordship, we filed a report. During the pendency of this proceeding, we filed a report that the government has taken a decision to do away with the project, Your Lordship, to dismantle the project.
Yes, it's a donation. You've taken a lot of this one question of that. See, if you take page number 30, annexure A, 1.3,
Well,
the miscellaneous application,
well,
it appears that some persons have donated the land.
well.
This fact was not brought to the attention of the learned single judge. Probably this was not available, or we do not know. Now the problem is, they have decided not to acquire. You can't compel them to acquire. Number two, if there is a donation, then it appears that you say no donation, then it's a disputed question of fact. How can this court decide the issue?
Well, I'll come to that matter. With Lordship kind permission, I'll come to that point. In the first writ petition or writ petition, my lord, they never take this plea that the land was donated. The plea taken by the state was that we conducted the survey. Yes, there is an affected area. Damages at the cost of 6 crore was calculated. That was the positions. They never take the plea that the land was donated by you to the government. So therefore, you're not entitled for compensation. You're not entitled for damages. They never take that plea. Therefore, Learned Division Bench passed that order.
So let them be implemented. We'll hear them then pass orders.
My lord, if Lordship just...
No prejudice is going to be caused.
My lord...
If the persons are going to be heard. We'll hear next week itself. So notice.
I'll just take the pleading of the application, my lord. Paragraph 4 of the application itself, I'll just point out one point of it. Lordship, I believe that I will satisfy that. Paragraph 4 of the same application, my lord.
Paragraph 4.
Paragraph 4. Wait, just read out, my lord.
Paragraph 4.
Paragraph 4, my lord.
Yes.
That the applicant herein further back states that the honorable court was apprised of the fact that the land which is submerged as a result of the construction of the dam, the entirety of such a land is covered by an agreement dated such, by which the Kairim, my lord, Kairim same ship donated the land for the purpose of the dam upon obtaining the same from Srimati Sumarman. Petition number 1, my lord. 9 petitioners are there, different plot. Appellant, hearing appellant response number 1. It is pertinent to state that the deed of agreement dated same date was executed between the state government and the Sengsuki Southern Pashanong, Kairim Semship, represented by 4 headmen who apparently been kept away and not made party to the series of litigation before this court. The headmen said such. Now, the content of this application is land was donated by the appellant number 1 to the Sengsuki Village Authority, and my lord, CMship is a traditional institution, has given this land to the government. That is the first content. Second part is the same agreement was signed by the state government and the Sengsuki. Now let us see the agreement, man. But and my lord, we see page number 13, the agreement.
Page number?
13, my lord. 1, 3.
Yes.
My lord. The content, my lord. May I read, my lord? As duly authorized by the third part of Sengsuki Saurung Pashanong, Kairim Semship, herein of the court, the Sengsuki Saurung Pashanong of the one part, Lordship Guidance, and Srimati Sumaman Lingdo Nongpri, reciting such and such on the other. Now, this is an agreement between her and the other side. Now, may I come to the last paragraph, my lord? Now, these parents, witness, and parties have agreed. Srimati Sumaman Lingdo Nongpri has agreed to donate her situated land at Sunset as per the map annexed herewith and the boundary indicated thereon in connection with the above mentioned water supplies scheme free of cost without any compensation and free of any charge or taxes whatsoever, and on such land shall vest with the village Tapar free from all encumbrances. Now the signatory is, my lord, the next page. For him means I appear to be the signatory, and the appellant number 1 is a signatory in the affidavit sheet 9. Well, government is not the party. CMship, my lord, is not the party, my lord. Now the government made by the applicant, Lordship kindly see, this land was not donated by me, but donated by the same ship to the government. One partner. And where is the agreement between the state government and the same ship?
So these persons must be village heads,
But they are the locality village headmen.
whatever it is.
But the content of the my lord, this chief is a different my lord. Chief is the entire my lord, the local institutions, tradition institutions, permitting many villages. Now the para 4, it says, my lord, the land was donated by the chief, my lord,
Correct,
to the government.
correct.
My lord, there is no agreement between the chief and the state government. But they said in the affidavit para 11, my lord, para 4.
Any event, they are not interested in acquiring the land, how they entitled to compensation.
My lord, therefore, little single bench may I just point out the little single bench direction, which they have complied already, madam.
See, first of all, you must understand whether there is a donation or not need to be divided. If there is a disputed question of fact, after this person got impleaded, then we may not entertain the petition at all. That is one aspect. The second aspect is, even without this impleading petition, there is no right on your part to compel the government to take over your land.
For that to give my reply, lordship, if lordship hear me, may I just point out the relevant portion of the single bench direction, which they have complied. In the memo of
We will implead them, sir. We will implead them. We will say that they are necessary and proper parties, and we will hear them and pass orders.
my lord, they are not necessary part. Therefore, otherwise, I won't have objection. Ma'am, I'll just place one Supreme Court decisions.
Anyway, we will have to reject against this order. There will be an SLP.
My lord.
Then there is not going to be any at all.
Absolutely a stranger, man. May I just take the operative portion of the single bench judgment? Lordship, kindly come to that operative portion. Para 15, madam. Para 15 of the judgment, madam. Page number, Lordship, kindly.
16 of the impleading petition.
My lord, memo of appeal, my memo of appeal. May I just come to memo of appeal. Memo of writ appeal.
Memo?
Of writ appeal, man. Page number, my lord, 371. I'll come to relevant the operative portion.
Which page, sir?
Page number 371.
371.
370.
Yes.
71. In this backdrop of the events and circumstances, where nothing is clear to facilitate conclusive adjudication, this court, in the absence of any due process being adopted by the respondents, and looking into the plight of the landowners who may or may not have been affected after 2011, but however have been pursuing this litigation, deemed fit, in spite of presence of disputed facts, to direct as follows. But the respondent in the PHE department shall, from available records, such as the detail contained in the affidavit filed by the state respondents in the WPC number sunset, which is annexed to the writ petition, as well as by fresh survey, identify and establish as to whether the lands of the petitioners remain submerged after 2011. Madam. Number 2, my lord. If the same after survey and examination is found to be true as alleged by the petitioners, the respondent shall initiate the process for acquisition of the said portion of the land and have remained submerged till date. If it is found otherwise, that after only instance in 2011, portion of land had been submerged, which has been not occurred since, of the due identification of the owners and the plot that were affected in 2011, the collector shall, from the amount of rupees such and such deposited by the PHE since 2018, apportion their said amount as compensation to landowners of the due assessment examination of their respective plots. My lord, Direction number 1 has been complied with during the pendency of the writ petition. And they have given a report, my lord. And the report, my lord, may just come to my show cause reply. The survey report. My lord, may come to page number 129 of my show cause reply. The report given by the government in pursuance to single bench direction. Page number 128.
120?
128, 128, my lord.
Yes.
My lord. Starting from para 2, may I start?
129 is the photo.
128,
128 is the photographs.
my lord. 128, my lord. My lord is looking to my the show cause reply to the missed case, my lord. Not the memo of appeal for the time being. My lord, I filed my show cause in the missed case. Page number 128. This is the detailed report pursuant to single bench direction. And may I start from para 2, my lord. It is most respectfully submitted that when the instant matter first appeared on 6/6/2023, the Honorable High Court was pleased to observe the real controversy as to whether parcels of land belonging to appellants herein have been lost to the appellants forever, or they only remain submerged for some period of time, 2021 to 11. If such lands continue to remain submerged periodically ever since the construction of the dam, it would then amount to the appellants having lost their land and the state having de facto taken possession thereof, otherwise than by the procedure established by law. In view of the above, the High Court was pleased to direct the state to immediately ensure that photographs of the entire area, including the parcels of land claimed by the appellants, are taken by drones to establish the present possession upon notice the appellants, herein to be represented by one or more representatives at the time the photograph has been taken. As directed by this Honorable Court, action taken report, the survey department is being submitted herein as follows. 21/6/2023, survey team proceeded to the site. However, survey work could not be taken up due to heavy rainfall and poor visibility. The list of the members who were present in the site is enclosed. On 22/6/2023, the provision of global navigation satellite system control points were carried out and completed on the same day. On 23/6/2023 to 27/6, detailed survey is using electronic total station of the individual plots and the extent of the boundary or portion of the submerged or affected land by water due to the construction of the dam was carried out jointly with the officers of the PHG Department, Office of the Deputy Commissioner, in the presence of the landowners, namely Stream Deepener, Sunset. These are the landowners they present. Number 4, my lord. It is more simply submitted that the boundary or the area of the submerged or affected area and the boundary of the individual plots remain unchanged in compared to the boundary or area as surveyed in 2011. My lord, the land in 2011 also they found it is underwater. They say now it is remain the same, position that remain the same. The areas plot of land are given herein below, table below. Petitioner's names started from say number 2. Petitioner number 1, Manungpi. The survey found that we are the landowner. And continue, my lord. And total area of submerged area is, my lord, 1.22973.47. My lord, square meter. It is underwater. Now that the entire contention of the state government that it is not underwater was found incorrect. Therefore, no single bench direction was carried out and they found it is underwater.
Now, all those things may be factually correct, sir. Now, we would like to know how you can compel the government to acquire the land. That's the point.
That's true, madam.
This is the first question we are asked. Now, we are repeatedly asking this very same question. How can you compel? Where is the provision to say the government is entitled to acquire the land? When they acquire the land, they have to pay compensation prior to the 2013 Act that was prevalent. If they have not acquired and postponed it, then 2013 Act comes, they have to pay compensation in terms of 2013 Act.
But-
They say they don't want the land at all. How do you compel them to take the land? That's our question.
My lord, pertinent question, Lordship put, my lord. My first answer would be twofold, my lord. One is, my lord, since the state did not file an appeal against the state did not file an appeal against the single bench direction. My lord, single bench direction is not a conditional one. Single bench took a look.
No, the original order was directing the authorities to consider on your representation.
But that was over, my lord. Thereafter, my lord, Chief Secretary had taken decision to acquire my land, and subsequently they review and they file another affidavit in the second round of writ petition. And thereafter, my lord, single bench has given this direction that earlier also Learned Division bench has given Chief Secretary
Sir,
to take a conscious
When
decision.
the land has got to be acquired, the notification has got to be issued, is it not? Where is the notification?
Madam, I pounded to that. Now, only my lordship put a question to me that how can the landowner can compel the government to acquire my land. My humble submission is this, my lord. Single bench directed the government, you conduct the survey.
Huh?
Single bench given direction to government, you conduct the survey. If the land is not underwater, you pay the damages only. But if the land is underwater, you have to acquire the land. Now, if the state doesn't want to acquire my land,
Then the court give a direction to that, sir.
my lord, the
We
direction is,
cannot shift it to the administrative side.
my lord, let the single bench direction, that is the
So
direction.
Lakshman Rekha is there.
Lordship, I really bow down, my lord, the query. Let the single bench direction is very clear. Now, assuming that for the time being, that they are not compelled to acquire the land. What is the law on, my
Sir,
lord?
you were,
Government can,
1 minute. Sir, whatever said and done, they've lost the land.
Lordship.
They lost. How much compensation you are willing to pay? That's all. They want money. Leave alone. See, if you want to write, if you want, we can confirm the order. On technicalities, if you want to dismiss this case, we can dismiss the writ petition. It's not a problem. Now the issue is, the poor people have lost the land. You have decided to take the land. Decision will not, unless it is culminated by means of a notification, it will not come into force. We agree with you. But they've lost the land. Poor people have lost the land. What is that compensation? And you have already agreed.
That 6 crores, something, Your Lordship, that is the amount determined, Your Lordship, for the damage caused in the year 2011, Your Lordship.
What is the 2011? What is the compensation you want to give of 2011? Go by the new act.
No, Your Lordship, in 2011, as I have submitted there, Your Lordship, there was a rising of the water level and land had been submerged, Your Lordship, and crop were damaged. And to compensate the damages caused to the crop, Your Lordship, an amount of 6 crores had been sanctioned, Your Lordship.
At that time.
At that time, Your Lordship. And now, Your Lordship, now,
Why don't you release that 6 crores together with interest?
Lordship, that order is already there. Your Lord. If Lordship kindly come to the
Council, don't go into the black and white and all.
Lordship,
Now they want to see the black and white is not the one. They want to see the color of the coin.
Lordship,
Now 6.7, nearly about 7 crores.
Lordship, yes.
It is 2011.
Lordship,
We are in 2024. 13 years have gone by.
Lordship,
And to you, why don't you pay that amount with together with interest?
Lordship will.
You can give a quarter to the man.
I'm sorry, my lord. My lord, I have one submission to make, my lord.
Yes, Mr. Ahmed.
My lord, what has happened, my lord, in this case, that the issue arose, my lord, that because of submerging
No, you-
certain areas,
No, I know he's advocate general, but he is representing whom?
The state, Your Lordship.
I'm representing the state, my lord. I'm
Lordship, yes. We have to get Your Lordship.
Double barrel gun. Only we can have.
well,
Yes.
this is the attempt made by the government. Drop it.
Yes, Mr. Amit.
Yes, my lord. Your lordship may have it this matter tomorrow. I will be physically there, my lord, and I will place this case, my lord. What is the fact, my lord? This 6 crore rupees was for acquiring the land, my lord, not for the paying the compensation, because one
For the
crop
damages
of
only.
certain area was destroyed, not for paying the compensation with regard to crop only, my lord. Those are the facts which
Advocate
your lordship
general,
may have it.
we have gone through the papers. Both the council have correctly placed the facts. Now, the issue is you have agreed to pay some 6.6 crores as compensation at that point of time.
For acquiring land, my lord. For acquiring land.
Whatever it is.
Because they are not ready, they say that I will give you land in 70 crore rupees, not in 6 crore rupees. 6 crore rupees we have been always willing to, but they say that under the new act, you have to, because
So we
first
are
they
not
donated
concerned about the
land.
new act. The decision was taken earlier. That is why I said, that is why we also put a cutoff date. If it is 2013, the compensation will be more.
Yes, sir.
So we are not saying like that. So 2011, a decision taken, unless it is notified, the question of acquisition doesn't arise.
Yes, sir.
So the other disputed question of fact insofar as that is going against the writ petitioner is that land has been gifted is a submission made by your colleague. So
Yes, my lord.
Whether
Then
the action
they
is taken place or not, we cannot go into that. What we thought is,
Yes, sir.
initially you have agreed to pay about 7 crores. Why don't you pay that 7 crores together with the interest?
Your lordship, I will take instruction specifically on this issue, but the problem is, my lord, they are not saying that they will part with the land in 6 crore rupees. If they are ready to part with the land,
No.
I can take instruction.
No, you pay that amount to take the land. We'll make it very clarify that. That's all.
I will take, my lordship may have this matter tomorrow, my lord. I will take the instruction on this issue.
Lordship.
For orders tomorrow. That's the only issue, sir. You can also get instructions. Otherwise, we may say that the disputed question of fact will say that you have to work out the remedy elsewhere. Then ultimately another 13 years.
Your lordship may have it day after tomorrow. One day more.
If you go to litigate for another 13 years, either your body will be immersed in the water or buried somewhere else. That's all.
Because, my lord, the problem is that the cost has gone up so much because we are providing drinking water facility to few villages, my lord. And now if the land cost is paid, it will be more than 70 crore rupees. We will be in better position to supply them by distillery water if I have to supply, my lord. That is the cost.
Section 93 of the new act is very clear that government after occupying the plot without due process of law, they can work.
So therefore, we decided to dismantle the entire. They decided to take that.
1 minute. See, we are trying to help the poor people only on the ground that a decision has been taken. Mere decision will not culminate into a notification acquiring the land. That's all. So, in order to give a quietness to the matter, we accept it with a reasonable interest and give a quietness to them. Let them take the land and develop it.
Madam, let the HE take instruction with interest.
With interest only, we have paid with interest. That is the bank rate prevalent today, that you can be given, that's all. 6% or 7%, whatever it is. We'll see about it.
Tomorrow. I love it.
Lord, may have it day after tomorrow, my lord. Day after tomorrow, my lord.
Day after tomorrow, yes, day after tomorrow.
Yeah.
Highly obliged.
Thursday.
Item number 8.
Thursday, for orders. Yes.
Lordship, the respondents were required to file their affidavits, Lordship.
May I please, Your Lordship? I may be, yes, just yesterday I received the parawise comment, Your Lordship. So I may be.
You need not bend this side. You can take the mic towards you. Yes.
Your Lordship, just yesterday I received the parawise comment. So I may be allowed 2 weeks time to file my reply in the case, Your Lordship. But
Yes.
Your Lordship, I beg to submit that by the order dated 19/12/2020.
I think there is an interim order operating against you.
Yes, Your Lordship, against you, against me, yes, Your Lordship. But what is this, Your Lordship? This petitioner has alternative opportunity or avenues.
See, you want time to file a reply.
Yes, Your Lordship.
The request, interim order to continue till the next date of hearing.
Much obliged, Your Lordship.
Item number 9. Your
Yes, sir.
Lordship, we have to file an affidavit bringing on record certain documents, orders which were being passed by the respondents. Your Lordship,
You want to file?
we have to file an affidavit bringing on record certain orders passed by the Income Tax Department. And Your Lordship, we received some more documents yesterday from the petitioner. So I'm praying for some more time.
You are for the petitioner.
I'm for the petitioner, Your Lordship.
So you have got the benefit of interim order and taking time.
Your Lordship, we received some more orders from the Income Tax Department in that.
That is right. You only took time on 7/2/2024. Interim order passed earlier to continue. Earlier means there was an earlier order is also there.
20th/12, Your Lordship.
Prior to 7/2 there was an order.
Your Lordship.
Your 2012-2013.
Your Lordship.
2 months have gone by. Almost 2 months. 2 months have gone by.
Your Lordship, on
But you are
the,
enjoying the interim order without filing a.
Your Lordship, on 6th, there was vacation in between. There was winter vacation in between, Your Lordship. Then,
There was winter vacation, Lordship, in between, Lordship.
Winter vacation is not to enjoy the vacation. You can enjoy the vacation, you can also do the work.
Your Lordship, after winter vacation, the matter was fixed on 7 February. So we received certain orders, and yesterday also we received some more orders.
When do you want?
Lordship, on Tuesday, Your Lordship.
Tuesday.
Tuesday, Your Lordship.
If you don't file, we'll vacate the interim order.
Your Lordship.
At the request of the appellant, petitioner posts the matter on Tuesday.
Lordship, interim order may kindly be extended.
Interim order extended till the next date of hearing.
Highly obliged.
Item number 10,